In this chapter, we will cover criminal liability to include the Bill of Rights, as well as protections against cruel and unusual punishments and double jeopardy. So as we learned in Chapter 1, laws do come from the United States Constitution. We also get our Bill of Rights from the United States Constitution, and they come in the form of the first 10 amendments. The first 9 amendments are the ones that contain protections for individuals, and these protections are to protect the people from their government. So the Fourth Amendment protects people from unlawful searches and seizures. In many of our criminal justice classes, we cover the Fourth Amendment in detail because it is an important concept for students to learn what an unlawful search and seizure is, as well as what the right of privacy is. The Fifth Amendment covers protection against self-incrimination, and that is you cannot be made to testify against yourself or to give incriminating evidence or incriminating testimony. The Sixth Amendment guarantees legal counsel for the accused. If you watch crime shows like Law and Order, you may remember when they're reading them their Miranda warnings, they say you may have the right to an attorney if you cannot afford one. And that is the big conception there, is if you cannot afford one. And the court sets the standard on who can afford one and not. The Eighth Amendment prohibits cruel and unusual punishment. Historically, people have tried to argue that the death penalty is cruel and unusual because they don't know what the body goes through when a person is being injected with the syringe from the death penalty. That has not stood up in court, by the way. Due process is basically saying that you have to have due process of law, that it has to be fair, and you have to have the opportunity to be heard. It also says that statutes, which we covered in Chapter 1, which is another area that our laws come from, that they must be specific. They have to provide reasonable and fair notice of what's illegal. They can't be so overbroad that there would be some ambiguity there as to what the law means. Due process applies to both federal and state governments. We are a dual government system in the United States. Therefore, we have a federal system and we have the state system. The Fifth Amendment protects individuals from the federal government, and the 14th Amendment protects individuals from the state government. So then we get into the concept of jurisdiction. And jurisdiction is basically gives the court authority over a particular subject matter or a person. So if a crime occurs in Beaufort County in North Carolina, the court that has jurisdiction of that is the Beaufort County Court. So if I'm caught speeding down Highway 264 just outside of the college, I'm in Beaufort County. If I get a citation for that, I will have to go to court, and the police officer will direct me to report to the Beaufort County Courthouse. So I wouldn't be tried in Hyde County, for instance, because they don't have authority over that particular criminal act because I wasn't within their jurisdiction. Now, jurisdiction also refers to federal and state governments. So the state jurisdiction basically says that individual states have the authority to make their laws that will promote the safety and welfare of its residents, and most of the criminal prosecutions occur under the state court systems. Therefore, once again, if I break a North Carolina general statute law, then I will be prosecuted in a court inside of North Carolina, inside of the county that it happened in. Some laws are federal laws, meaning that you can be prosecuted by the federal government, and it's based on the United States Constitution and the Interstate Commerce Clause. So, for example, if someone kidnaps a person and they carry them across state lines, they have committed a state violation as well as a federal violation, and they can be prosecuted in both the state and the federal court systems. Now, oftentimes you will see this with bank robberies. Someone robs a bank that's federally insured, then they have committed a state violation of the act of robbing the bank, but they have also committed a federal act because that building is, or the money is federally protected, therefore they violated a federal law. So they could be prosecuted in North Carolina for that law if it occurred in our state, and they could also be prosecuted in the federal court system. Venue refers to the area where a person will be tried. So like I just said, if I break a law in Beaufort County, I'll be tried in Beaufort County. However, there are some circumstances where a trial might receive so much publicity in the local newspaper and local news where the defense attorney will argue for what's called a change of venue, meaning they want to move the trial outside of the area where it occurred because they don't think that the defendant will get a fair trial due to the publicity. Sometimes the judge agrees with that and they give them a change of venue. Sometimes they don't and say that the person can get a fair trial and they will be held accountable in the jurisdiction where it occurred in. Most often, venue is changed from one location to another if the court determines that the defendant cannot receive a fair and impartial trial due to the pretrial publicity. Then we have the right to privacy. This is a right that's not explicitly guaranteed by the Constitution, meaning it's not exactly spelled out word for word. However, the United States Supreme Court has ruled time and time again that it is a right and is guaranteed under the due process of law. Therefore, that means that if I am not breaking any laws and police do not have a search warrant to come inside of my house, I have a right to privacy inside of my home and they can't barge in and search my house. Right to privacy covers many different things. We get into that later on in the chapter, but just know that law enforcement they do have to abide by a person's right to privacy. Then there's the principle of legality. And the principle of legality says that if there's no legislature that prohibits a specific act, then there is no crime. Now, we'll go back to my speeding episode. Let's say I'm speeding down Highway 264 in front of the college, and, well, let's say I'm not speeding. Let's say I'm driving 55, which is the speed limit in front of the college. So I'm driving 55 today, and tomorrow they change the speed limit to 35 miles per hour. A police officer cannot come find me and then give me a ticket for what I did yesterday when there was no crime against it. And those are called ex post facto laws, meaning you can't be punished for something that wasn't a crime at the time it was committed, even if it later on becomes a crime. Equal protection under the law is guaranteed to all people under the 14th Amendment. It means that criminal laws can't discriminate based on the person's sex, race, religion, ethnicity, their national origin, and sometimes even their age. Then we get into the topic of double jeopardy, and this is one of your chapter objectives for this week. Double jeopardy says that a person cannot be re-prosecuted after they've been acquitted. So what this means is if a person goes to court and they're tried by a jury or a judge and they are found not guilty, the state can't come back later and when they get more evidence and try that person again. Once they are found not guilty, they are off the hook for life. There is a movie about this that actually explains it in perfect detail, where a woman was charged and convicted of murdering her husband, where he set her up. When she finally got out of prison, he came back to hurt her, and she killed him. Well, she couldn't be prosecuted again because she had already been prosecuted. So that's double jeopardy. The Fifth Amendment is what gives us the protection from double jeopardy. It means that the police can't, after you've been found not guilty, they can't keep trying to take you back to court multiple times until they get a conviction. It also prevents the government from stacking convictions and punishments. So if John murders Mary, in the process of murdering her, he also assaults her. She will be tried for murder and not the assault. They can't charge her for both of those because that would be stacking the convictions, and it's a lesser included offense. But a person may be tried twice for the same criminal conduct if the conduct constitutes two different crimes. So remember my example from the bank robbery. If you committed one act, you robbed one bank, but you broke two laws. You broke a state law and you broke a federal law. So both courts have jurisdiction over that person. Now, oftentimes, the state or the federal government will determine which one of those or which entity is going to pursue the charges, but it is not illegal and it is perfectly acceptable for a person to be convicted of the same crime in two different courts if it is state and federal jurisdiction.